Sholabha H. Sheshadri, LLB BLLB student, Savita School of Law, Chennai, Tamil Nadu.
So my name is Saulabhya Sheshadri. I'm from Savita School of Law, Chennai. And I'm doing an empirical research which is titled that Closing the Divide, a comparative study on the differences between legal pedagogy and the professional practice on how to integrate the same for enhanced practice. Before I start, I would just like to start with a quote that is Dharmo Rakshati Rakshitaha. That is, Dharma will protect those who protect themselves, those who protect Dharma itself. So starting with this, I will just like to point out the contents of what I'll be speaking in the next 10 minutes. The introduction, a brief history on legal education and the current scenario of legal education in our nation. Theory and what is theory, and or do we go on to the principles of practice? And the next one will be, does skill trump knowledge of practice? And what is the sine qua non of practice? What are the measurable outcomes that can be created? And who is a competent legal graduate? And I'll also be talking about the objectives of this study, and I'll be showing my analysis part, which I've asked, it's a very limited analysis, sir. I've mainly asked only academicians and advocates and some interns also for this. It's a very limited study. I have 50 responses for this table, sir. And I've used bar graphs as SPSS for showing the analysis part. So if you're satisfied, may I move on? Yes. Okay. So let's start with the introduction. So we know that the field of law is a cornerstone for upholding the principles of natural justice and whatnot. But the thing is that even though it was not codified since the beginning of time, but they were always existent for people. Let's say, for example, when we go to the history of legal education in our nation, let's say for the Vedic period, we had something like, we had the Vedas, we had the Rig Veda, Yajur Veda, Atharva Veda, and the Sama Veda. But the Vedas were not available for all the people because they were spoken out, and they were to be heard by only specific sets or groups of people. But then later they were, in order to make it simplified for all man to follow, the Manusmritis were brought in, which were based on the Vedas as a principle of life. Manusmriti literally means principles of man, which are to be followed by men or by people in order to lead a harmonious and good life, which can ultimately help them reach moksha. That is, it can help them reach salvation for their life. But since there was no scientific or evidence that any form of legal education was definitely present during the Vedic period. However, when the Mughals came in, when there was an invasion of the Mughals in our nation, Baba brought in the first time of, let's say, court systems in our nation. And they also based their court systems on particular texts such as the Fiqh-e Firoz Shahi and the Fitwa-e Alamgiri, which were appointed, and all officers and judges were appointed, and they were ensured that all the judgments and pronouncements which were given were in the path of Allah and in accordance to the Quranic text. But after the Mughal period comes the British period. Here is when really legal education was brought into India. Even though there were madrasas which were used during the Mughal period, which were only specific sects of people were allowed to go to madrasas and learn about the law in order to become judges or in order to become, let's say, vakils or something. That's like a common term. But the British are the one who brought in legal education to our nation. They introduced it as a subject for people so they can learn. But however, it was a biased thing. The problem was that in order to learn legal education through the British system, you first had to be an English-speaking Indian. Without learning English, you were not allowed into a college of law during the British period. Three main universities in the presidency towns of Calcutta, Madras, and Bombay were all set up. But since the national language for the British India was English, there was a huge language barrier which did not allow people, Indians, to learn their law and also help them, so which caused a lot of exploitation among both the British and the Indians. But let's come to the current scenario. Now we are 1/4 into the 21st century. Legal education system now currently in India, and according to the Bar Council of India rules and regulations, we give both practical training as well as theoretical training. Students spend 3 to 5 years in law colleges and law institutions, in order to help them prepare themselves for the future. And it's not only a single scope. It's not that the moment they finish studying law, that they immediately need to be an advocate. There are other scopes also for them. They can go into arbitration, there is mediation, they can even become counselors, there are many other, or they can join a law firm. There are so many possibilities and so many vast areas which can be covered in this subject. But what is the main problem when it comes to this, which is what my basic study is, that there is a huge difference when it comes to practical knowledge of law and the theoretical knowledge of law. The theoretical aspect provides the students with a solid foundation on the knowledge of principles of law, whereas practice does not ask you whether you know your principles. Practice asks you whether you are thorough in knowing how to file a particular thing. Whenever a student, let's say for example, a student enters an internship office, and the first thing, and the office also gives them certain work. The moment they try to finish that work, the first question most of the students, even I have faced this being an internship student, is this what your college had taught you? This is the most asked question to any internship student the moment they enter. Yes, many students are prepared nowadays when they enter law colleges or when they enter internships. But being prepared alone does not help them be prepared for the practical aspects of law. Moving on to the next one, does skill trump knowledge? In my opinion, is that skill sometimes just definitely trump knowledge. But I'm not saying knowledge is a bad thing. Without knowledge, you do not have your basic foundation in the law. The law is a very vast ocean. We only study few droplets of it in order to trying to understand those few droplets. Without being able to understand the knowledge, we will never be able to practice and test the skill in order to get an outcome right for us. So I've divided into three things in skill. Does skill trump knowledge? As knowledge, requisites, and skill. Knowledge is as I said, is the most fundamental aspect of any lawyer or advocate's life. But learning to use those skills, to use that knowledge effectively, is what is most important for practice. But when we come to the skill side, without being able to have hands-on experience regarding procedures of court, or how court works, or even how many sections of court, sanctions of court, or what are all the petitions, or what are all the documents which need to be filed in order to file a petition, or in order to start a trial, all these things need to be taught to students so that they just don't chase academic excellence, but they excel in their future life also. So the requisite, mainly I feel, is that what a lawyer or an advocate must have is that they must have a deep understanding of the law itself, but they must also possess a range of skills in order to be successful in their career, no matter what it may be. They can be a lawyer, or they can even become an advocate who is in litigation as well. Next is the sine qua non of practice. That is, I've divided this, as I've shown this categorically, in steps, because I feel that in any student's life, without education itself is like a staircase. Once you cross one step, you are able to go to the next one. So without being able to cross all these steps, you will never be able to reach the top step, which shows the fruit of your final outcome of what you've been practicing and studying for the past 5 or 3 years of your life. So I feel that the first main thing is that lawyers are expected to be wordsmiths. Their language and communication skills is an extremely important factor that any lawyer or advocate must have. Yes, you should have knowledge about legalese. Legalese is what we can call the language of law. But you should also be able to explain legalese in such a simple manner, because you'll be interacting with a client. Your client does not understand anything about law. You will be the person who will be speaking on behalf of your client when you're in front of a court or in front of a bench. In order to first understand, you have to make the client understand that these are all the outcomes which are possible, these are all the outcomes which can be made, and these are all the options available for any person if you want to enter litigation. And one more thing mainly I feel is that there's a language barrier. Yes, there's a whole thing about Hindi, Tamil, whatever there is. Language is an important thing. There are people who are let's say, what's this thing called? Sorry. Judicial people who work in courts. There are people who are translators. They are not being given any form of examination, nor do they go through any form of law school. But they are well versed in several languages in order to help them translate something of a client. Like, for example, a client comes from another state or from another country, but they are still able to translate that. Why? Because language is a huge part. Whatever happens in our nation, the law is the same for everyone. But the language can become a huge barrier for any other person. Another main factor that needs to be addressed to students is that this is not, I'm not stating that all students go through this, but this is most. I do agree, many students come prepared. They do know this. Many students are well versed with language and well versed with communication skills. They are well versed with attitude. They are well versed with responsiveness. And they are also able to adapt to unforeseen circumstances. The main thing in any advocate's life, if we ask them, is that whatever happens in court, there will always be a twist with whatever happens which can throw them off. They should be able to adapt to that immediate circumstance and be able to switch up their argument in order to ensure that the argument is still running in their favor when it comes to the judgment. And legal research. Without being able to research properly and accurately and still being in a concise manner, without being able to search on their necessary case laws or judgments or whatever, or even maxims or torts or whatever they need, without being able to go through all that, they will never be able to draft a perfect paper or a perfect argument in order to stand up in front of a bench. I would like to move on to creation of measurable outcomes. That is, these are certain outcomes or measures which I feel that can be implemented in law schools or law institutions, even though many of them are being implemented, which can be made compulsory for all law institutions, so that when students step out of their, after they step out after graduation, they can step out hassle-free. They won't be able, they don't necessarily need to go through all that pressure that they have to excel without knowing anything. So I feel that certain outcomes is that, like, making compulsory of moot court competitions, mock trials, client counseling with a larger and higher marking weightage. Many law institutions, yes, all of us do go through moot courts. Yes, we are given client counseling, trials or mocks or anything like that. But why is that for a lesser marking weightage? Yes, subject is important, but this is also an important. Without moot courts, we will never be able to argue properly in front of a judge. One more thing is that staying current with latest legal developments, collaboration with both legal academia as well as the legal industry, having lectures and whatever. Providing training on speed and persuasive writing. Without with the ability of having to write persuasive arguments, you can never convince the judge that, yes, my point is right, Your Honor, without being able to give those proper points in front of the judge. It should be accurate yet persuasive to the judge that, okay, yes, this person's point does make sense. We should try to look into their favor as well. And also two main other measures I feel is very necessary other than all of these is that teaching passion for the subject. Half the students who come into law institutions, yes, they are very passionate about their subject. But the other half, they are coming into the subject because of either a friend or a family wanting them to enter the subject. They enter the subject itself without any form of passion or heart towards the subject. So I feel that those students who do not have a passion towards a subject, they will not try to excel, which will lead them to having so many other downfalls in their life. And one more main thing is that coaching students with people and social skills. An advocate must be able to talk to anyone or about anything impromptu on the spot without having the slightest hesitation or anything like that. But the thing is that not all people have the same social skill or the level, or they don't have the same social patience. So those and those students who are being let's say, weaker when it comes to social skills or communication skills should be given specific coaching skills in order to help them at least talk properly to another person so that they can communicate with a stranger or a client or even a judge or even their opposing counsels. These are all the measurable outcomes which I feel can be implemented. And I'll move on to concept of legal graduate because I think time is running out. Then I'll just go into my analysis part. So what is the concept of a competent legal graduate? Why I've written competent is that the myth of a perfect legal graduate is non-existent. It remains a myth for any person. Any advocate, the moment they feel that an intern will come, they will feel, yes, this graduate will become the best person in my entire office. But that is a myth. No advocate will feel that. They want a person who's competent enough to complete the job which is given to them in order to ensure the advocate's reputation as well as when they speak in court is reserved, that their points are put out well to the judge and the judgment can try to come in their favor of their client. So, as I said, people skills, time management, legal research skills, integrity and professionalism. One more thing I feel that when it comes to law institutions, that especially when it comes to moot courts or when it comes to client counseling, is that yes, we are given a certain, let's say issue of fact or issue of law. But we never are going through the ethical dilemma and any advocate goes through when they are speaking for a client. A client may be approached by a victim or a witness or even an accused. At that particular point of time, the advocate's ethics should be in question, which is not something which we are taught, especially law students and law colleges. We are not taught how to deal with such ethical dilemmas or moral dilemmas. Let's say, for example, a person who's accused of rape is coming to you and say, will you be my advocate? You have to ensure that they should be taught how to keep their professional views and their personal views completely aside. For them, the client is the most important person. For them, the client should be ensured that the client receives the justice which they deserve. And ethics and loyalties towards clients, patience and communication skills. Any lawyer or advocate should be patient enough to hear any form of any problem which the client has or anything which happens in court or anything else like that. And I would like to move on to the objectives, that is which will conclude with my analysis part. That is to study the distinction between professional practice and legal pedagogy, to observe the real-world implications stemming from these disparities during practical application, to scrutinize the underlying factors contributing to the observed differences and explore potential results and resolutions, as I stated before, and to analyze the perception of academicians, advocates, and interns, and also research scholars regarding key disparities between both academic study and practical implementation, seeking ways to integrate both of them seamlessly for enhanced practice. I would like to move on to my analysis part. So should I go on with everything or just some certain few?
You have already exceeded your time period.
Oh, I'm so sorry.
Yeah. If you can quickly sum up within few seconds.
Sure. Okay. So through my entire analysis, I had found that many of the advocates do feel that yes, there is a huge difference between both legal pedagogy as well as when it comes to professional practice, and many advocates do feel that these resolutions which I had stated, and asked them same as to those to advocates and academicians, and they do feel that yes, if these are implemented, law students and law graduates will have a hassle-free internship term or an advocate's term. So to conclude, I would like to state, and also one more point I would like to add, so sorry to take up your time, that teachers are not allowed, or professors, they're not allowed to practice. So when we ask, so this the main thing, let's say, when an intern comes to an advocate's office and they're interning there, the first thing is they'll ask is, go draft this petition for me, go file this wakalat for me, go file this, go draft that, go do this. But since faculties or professors themselves are not allowed to practice, they do not know how to draft, they do not know how to file a petition or how to file a wakalat. If they themselves are not being educated on that particular aspect, how can we expect our faculties or professors to teach the same when it comes to our students? Oh, sure. Okay, ma'am. I'll research on that. Thank you so much, ma'am. And one more thing is that when it comes, I would like to conclude saying that because the BHU is such an impactful and such a historically impactful and very prestigious institution, that the BHU can be and can collaborate with the BCI, that is the Bar Council of India, and provide any form of resolution which can have a fruitful impact for all the budding lawyers of our nation, and also ensure that they are stress free, and when they come into the advocates world, they are true to their word which they took up their oath when they became an advocate. Thank you.